Is about to be shown is in support of a uniform process for federal elections, okay? That Congress can determine for federal elections for the United States House of Representatives and United States Senate.
In what may be the most important case about the processes of democracy ever considered by the United States Supreme Court, the court heard oral arguments today about this clause of the Constitution. The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But the Congress may, at any time, by law, make or alter such regulations, except as to the places of choosing senators.
That's Article 1, Section 4, Clause 1. I sent out an email in September of 2021 to all the Democratic senators, well, a lot of senators, and, well, the leadership and the House members also, about a uniform process for federal elections based upon a professor in Virginia, where it'd be across the board, uniform, and then you would have impartial, bipartisan, neutral arbitrators when there is an issue with respect to an election. All right, so that's not this. This is something else they're trying to do. But Congress does have the power, all right, and may have the power also to determine respect to the presidency of the United States of America also, according to the professor.
Republican state legislators in North Carolina have appealed a case to the Supreme Court in which the state Supreme Court of North Carolina overturned the legislature's congressional redistricting plan. Republicans are arguing that no state court has the power to do that because the Constitution grants the power exclusively to state legislatures. Their theory of the case is an obscure, fringe legal notion, not even justifying the phrase legal theory, that they call the independent state legislature doctrine. Here is some of what Justice Elena Kagan had to say.
I'd like to step back a bit and just, think about consequences, because this is a theory with big consequences. I think what might strike a person is that this is a proposal that gets rid of the normal checks and balances on the way big governmental decisions are made in this country. And you might think that it gets rid of all those checks and balances at exactly the time when they are needed most. Because legislators, we all know, have their own self-interest. They want to get reelected. And so there are countless times when they have incentives to suppress votes, to dilute votes, to negate votes, to prevent voters from having true access and true opportunity to engage the political process.
Neil Katyal, who presented a masterclass today in how to argue a case in the Supreme Court, rose in opposition to the North Carolina legislature. And here is how he rocketed out of the gate with his very first words to the court.
For 233 years, states have not read the Elections Clause the way you just heard. There are two reasons to affirm. One is that when enacting legislation, there's no such thing as an independent state legislature. The other is that North Carolina statutes authorize what the North Carolina court did. I'll focus on the first. Petitioner's idea that state legislatures created by state constitutions are independent of them is wrong. It is rejected by the Articles of Confederation, rejected by the early state constitutions, rejected by the founding practice, especially in New York, where judges vetoed federal election bills. It's also rejected by this court in cases such as Smiley and Hildebrand.
Joining us now, Janae Nelson, President and Director Counsel of the Legal Defense Fund, and Melissa Murray, Professor of Law at New York University and an MSNBC legal analyst. Professor Murray, let me begin with you and your reaction to what you heard in court today. It's just an open mic, no specific question. I wouldn't presume that. Go ahead.
Well, this is the kind of question I like most, Lawrence. So this was a rollicking argument from start to finish. As you say, the independent state legislature theory really doesn't even deserve the moniker of theory. It really is more like fan fiction. And the fans here are the Republican legislators in various state houses across the country who would love to be able to further consolidate their power by being freed from the constraints of having state courts use state constitutions to constrain them or restrain them for the purpose of having free and fair elections. So what we heard here today, as Justice Kagan said, is a monumental theory that will have enormous consequences if this court chooses to credit it. And it did seem as though there were at least 3 people on this court who were enamored of this theory / fan fiction. And the real question is, can they get 2 others within that conservative bloc to join them for a 5-person majority?
Janae Nelson, what were the highlights that you heard today?
Oh, there were many. One of them that I'll choose is what Justice Kagan asked. It's what you put up on the screen before we started, and that is, what are the consequences? And I think it's very easy to get caught up in the really lofty title of this theory that you mentioned, the independent state legislature theory.
Let me stop for a second. Notice on the right side, that's Justice Constance Baker Motley, Judge Constance Baker Motley. She would have been the first African American member of the Supreme Court, depending upon timing, everything's timing. But she is the first African American female federal judge in the history of the United States of America. Okay, the history of the United States of America. And when she graduated from Columbia, by the way, a white brother put her through Columbia named Blakesley. He met her when she was younger, in her teens, and she said, I want to go to law school, but I don't know how I'm going to do that, and like that, and financially. So he said, well, I'll put you through. And he did. And she graduated, and she went on to help Dr. King. It's a beautiful picture of her and Mrs. King and Dr. King together. Beautiful. Take a look at that. Now, as for Sandra O'Connor, she also graduated. She graduated from Stanford Law School. She was number 2, Windcroft's number 1. And when she graduated, the only job she could get was that of a secretary, right? Legal secretary, okay? Which is wrong. However, she could have, I point this out, she could have worked in the area of civil rights like Constance Baker Motley did. All right, so, and then Constance Baker Motley became the Chief Justice of, Second Circuit? And I think, but anyway, the fact is that she's the very first African-American female federal judge in the history of the United States of America. And there are others earlier in history could have also been on the Supreme Court, but racism as it was, we just got one recently, right? And the great Ketanji Jackson Brown, who understands American history, knows about the Civil Rights Act of 1875 and treat people equally, and all those other acts that were passed, and the original intent, the bedrock view of those acts to protect people of color and treat everybody equally. And that act of 1875, Civil Rights Act of 1875, was deemed unconstitutional in 1883 by the Supreme Court. And then you have Plessy v. Ferguson in 1896. Plessy was 7/8 white and 1/8 African blood, according to the Supreme Court. It was not discernible. Read it yourself. And he did the same thing that Rosa Parks did. Rosa Parks did on December 1st, 1955. He did in the 19th century on a train. Okay? And the Supreme Court, in that case, said, yes, but equals okay. Boy, history is something, huh? But knowing your history is so important. Everything we're seeing now was tried before in the past. There isn't anything new under the sun, as the Bible says.
But what's really at stake here is a power stripping from state courts. For decades, for 233 years, as Neil Katyal pointed out, we've understood that state legislatures are checked by state courts. They have to operate within the bounds of the law and within the bounds of state constitutions in particular. And state courts have been the check to ensure that state legislatures are not running amok, are not becoming lawless political entities. And that reins them in and checks the balance of power that we all expect to govern our elections. We know the Constitution allows state legislatures to determine the time, place, and manner, but they can't just do that without any check at all. And that's ultimately what this theory would require.
Professor Murray, let's listen to what Neil Katyal had to say about what he called, I believe this phrase was, the blast radius of this.
The blast radius from their theory would sow elections chaos, forcing a confusing two-track system with one set of rules for federal elections and another for state ones. Blast radius, by their theory, starts at the size extra large. It starts with invalidating 50 different state constitutions today. Elections clauses are in 27. All states have equal protection clauses, speech clauses, assembly clauses. 30 of them guarantee the right to a secret ballot.
And with all of that, I felt like that was almost just the tip of what was possible here, that it just felt like there was an unlimited set of implications here.
I think that's exactly right, Lawrence. Not only would this eliminate all of those provisions for free and fair elections that appear in state level constitutions, it actually has the impact of fundamentally altering the basic rudimentary election practices that we know, like whether or not you can have a polling place in X location. All of those things would be subject to the state legislature as opposed to a board of elections or any other kind of entity that currently regulates elections. And perhaps most problematically, this theory of the independent state legislature, if taken to its logical conclusion, is not constrained or limited to just this elections clause of Article 1. It could also be incorporated into Article 2's elections clause, and that deals with the electors in the Electoral College. And that's the theory that essentially those Trump allies, John Eastman, et cetera, were trumping and trumpeting during the 2020 election. This idea that if the state legislature does not approve of the choice of the voters in that state, under this theory, they would be authorized to provide their own slate of electors. So taken to its logical conclusion, it's not the issue in this case, but if taken to its logical conclusion, this would extend to that as well.
Yeah, Janae Nelson, there was what I considered panic talk in around September of 2020 about the Pennsylvania legislature maybe just seizing control of the Electoral College vote in Pennsylvania and just declaring it to be a certain number. But I kept saying that's impossible because the legislature has delegated the authority, in effect, to choose the electors to the voters, and they would have to pass a new law that a Democratic governor would have to sign into law, which isn't going to happen. And so it was all then impossible. This could make it possible.
Yes, and not only could it infect state elections, this will ultimately have a significant impact on Congress, on the way we are represented across the country. If we look at the underlying facts in the North Carolina case itself, it was a rank partisan gerrymander. The state is roughly 50-50 in terms of support for Democrats and Republicans. But if you look at the congressional map that was being challenged in North Carolina, 10 of the districts easily would elect a Republican representative. We're a nonpartisan organization, but we can see quite plainly that that is a partisan gerrymander. And it was just less than 3 years ago that the court said, the Supreme Court, that it could not intercede in partisan gerrymandering. In Rucho versus Common Clause, it said this is a matter for states and state courts. Here, the state of North Carolina does exactly what the Supreme Court said it should be doing. And the Supreme Court decides to take up this case and say that perhaps, and we hope that it won't go this far, that perhaps state courts have no check on state legislatures. And this will be the undoing of our representative bodies in Congress, the House, and it will have just, I think, enormous consequences, and we will not be able to put the genie back in the bottle.
Janae Nelson and Professor Melissa Murray, thank you both very much for joining our discussion tonight.
Yeah, thank you, Lawrence.
Coming up, Senate Democrats have a new hero. The now re-elected Senator Raphael Warnock returned to the Senate today. We will be joined next by Caroline Randall Williams, whose essay about the Georgia Senate campaign in the Atlantic is titled Herschel Walker is an American Tragedy. That's next.
Today is Wednesday, December 7, 2022.